Welcome to Liberty Protection Safeguards. It's the one that's replacing DoLS, so I'm just going to do a very quick whistle-stop tour of this. So the aim of the course is just to talk about the Mental Capacity Act Amendment, which passed in May 2019. So this isn't new, it's been around a while. It replaces the current Deprivation of Liberty Safeguards. The scheme is known as the Liberty Protection Safeguards. The course will provide an overview of the changes brought around by the Act. It will consider the differences between the DoLS and the LPS. It will outline what new processes will be. And hopefully it'll give you some support in considering how your roles and responsibilities have changed. And you've heard me talk about the LPS quite a lot. So the content then is a brief overview of the Liberty Protection Safeguards, looking at the importance around informed consent. We understand about the two-stage test of mental capacity anyway. What is DoLS, the acid test? We look at restraint and restriction. So we've already done that under the Restraint Reduction Network training. We look at the comparison of the DoLS and the LPS process, the legal criteria and rights. So brief overview then. LPS, Liberty Protection Safeguard, came in October 2020. It's part of the revised Mental Capacity Act Code of Practice that was published. LPSs now affect from 16 years old and covers the community and residential and care homes for young adults, or for 18 if they're in a care home. So that's the first change. DoLS Acts only were for 18 years over and only for those in care homes. The new Liberty Protection Safeguard covers the community and younger people. Any deprivation of liberty must be authorised by the advance of the responsible body. So the responsible body in this case is going to be your CCGs or the NHS or local authorities. So they're the responsible bodies. But they're the ones, rather than it going to a court, it's signed off by them. The responsible body, the authority of the deprivation of liberty, needs to be clear that the person lacks capacity to consent, so cognitive impairment, that the person has a diagnosed mental health disorder, so on record, that's what it means. The arrangements are necessary to prevent harm to the cared for person and are proportionate to the likelihood and severity of harm. The person-centred and family must be consulted to understand what the person's wishes and feelings are about the arrangement made. It is the personal objectives that a more thorough review of the care must be carried out, that the approved mental capacity professionals, the AM, must do this. If there is a potential deprivation of liberty in a care home, the care manager is then responsible for coordinating the assessment of capacity, so that's new. The care manager must then coordinate the judgment. The care manager must pass their findings to the local authority as the responsible body, and once authorised, must include regular reviews by the responsible body. Teams then, deprivation can be for a maximum of 1 year initially. This can be reviewed after 1 year and then for up to 3 years. So once you've done an LPS, once we've deprived somebody of their liberty, it's only for 1 year in the first instance, and then after that it goes to 3 years. Court of Protection will oversee any dispute. So what that means is everybody has the right to appeal against an LPS decision. It goes to the Court of Protection. The Act also brought about the scope to treat people and deprive them of their liberties in medical emergencies without gaining prior authority. So that's about doctors making life decisions for them, life-sustaining treatment. So if a person lacks capacity or the care provider needs to deprive them of their liberty to give life-sustaining treatment or any vital act to prevent a deterioration of the condition, the deprivation is lawful. So in other words now, hospitals do not need to get consent. They can give treatment based upon life-sustaining treatment, as long as it is an emergency and urgent steps are being taken to deal with this. Okay. Or care provider is awaiting for the decision from the Court of Protection or responsible body is already undertaken by the assessment of the deprivation of liberty. So if you already have a DoLS, they naturally will roll forward into the new LPSs. Equally, If you are waiting for a responsible body to come forward with a decision, you carry on in the best interest. We don't say we can't do something as long as it's in the system. And therefore, the deprivation is still lawful. So in other words, if you put an LPS in, the moment it goes in, it is lawful. Okay, so you don't have to wait for them to be approved, which is a new thing, because ultimately you are having to wait to get those certificates back. The care home manager will be notified by the responsible body if there needs to be an advocate in relation to the deprivation of liberty assessment. So what you need to be aware of as assistant practitioners is that the Mental Capacity Act was amended in 2019, and you should be aware of the 2019 amendments. It all came around from the importance of informed consent. We've covered that today. What is informed consent? Informed consent is about ensuring people are being fully informed about the decisions of their care and about the nature, the purpose, and the consequence. If a person cannot consent, then under the Mental Capacity Act, you can then be applied for an assessment of capacity to be undertaken. So the two-stage test for mental capacity. Stage 1, is there an impairment or a disturbance to the function of the person's mind or brain? So is there already evidence on their health record? So you don't necessarily need a current diagnosis. This can be an old diagnosis as long as it is a disturbance or impairment of the brain. Or if so, stage 2 is the impairment or disturbance sufficient that the person lacks capacity to make a particular decision. So in other words, is what's wrong with them currently now, does it impair them in making that informed decision? So we do the toilet test. So here, total test rate, they've got to understand the information being given to them, they've got to retain the information, they've got to weigh up the information, and they've got to be able to communicate their decision. So when we talk about the Mental Capacity Act, this is what we're talking about. They understand what the information is, can they retain it long enough to make a decision, and they weigh up that information and they can communicate. If they can, they've got capacity. If they can't, they lack capacity. Now, what is also new under the LPS, carers can undertake this assessment. So we haven't got time for that. Okay, so we've got the 5 key principles for mental capacity. So we know about working in the best interest and the least restrictive option. So anyone who works on behalf of a person who lacks capacity, it must be done in their best interest, and you must choose the least restrictive option when doing so. Someone making a decision or acting on behalf of a person who lacks capacity must consider, is it possible to interfere less with the person's rights and freedoms, and is there a need to decide or act at all? So in other words, have you got to do something? Can we just let it go? So what is a deprivation of liberty? Article 5 of the Human Rights states, and this is the bit about the restraint. When people said that they don't do restraints, this is what we're talking about. Anyone has the right to liberty and security of a person. No one shall be deprived of the liberty unless in accordance in law. So this is the acid test. Is the person subject to continuous supervision and control? So if you cannot leave your home, if you always have to have a member of staff with you, if you must be observed, then you are being deprived of your liberty. That is a restraint. And is the person free to leave? So if they're not free to leave, again, we know that's a restraint. So examples of deprivation of liberty. Each case must consider its own merit, addition to the acid test, and we need to consider what needs to be done. Now, you've already done your new RRN training. So that was the managing, controlling hazardous behaviour. And that was under the Restraint Reduction Network standards, which come in line with the LPS, the Liberty Protection Safeguards. And in there, we've talked about the fact that restraint isn't just holding somebody, it is that complete deprivation of movement as well. And therefore, you've got access to that and you've seen that already. So let's look at the key differences between the DoLS, the Deprivation of Liberty, and the new Liberty Protection Safeguards. So you can see on the left-hand side, we've got the DoLS, and on the right-hand side, we've got the LPS. So first of all, age. Under the DoLS, it applied to 18-year-olds. Under the LPS, it's now 16-year-olds. Settings, it was only relevant to hospital and registered care home. It's now hospitals, care homes, and community settings, including own home and foster homes of children. So that's new as well. And that, to be fair, that's been a long time coming. That should have always been there. Duration. So under the DoLS, it was a maximum of 1 year with no exception. Reviews are required by the responsible person and the AMPS. Under the LPS, it's 1 year, and then it's moved to a 3-yearly review. Timescales, then, the referral on specific forms, the clock's ticking as the process must be completed within a range of strict timescales under the DoLS. Under the LPS, and this is going to kill social services and the NHS. I have no idea how they're going to do this, but it's not our problem. They have 72 hours to get the decision back to you. So once you've raised that LPS, and that can be an email or a phone call with enough information, the responsible body must make an informed decision within 72 hours. So for all of you that have ever heard that term backlog, backlogs will now be illegal. So we are not allowed backlogs of DoLS applications. So that's a relief because that's been a real mess. Flexibility of the setting obviously covers settings. If they lapse automatically, the person moves. For example, if a person is admitted to hospital, the authorization ends there and a new one has to be done. Under this, as long as it's anticipated, an authorization covered during the settings, e.g. homes to respite care, it could be transferred with them. So new liberty protection safeguards have a bit more flexibility. Looking then who authorizes them, at the moment, the DoLS was the local authority. Didn't do so well, did they? Bless them. That was a lot of paperwork and a lot of legislation. Now it's local authority or NHS hospital bodies. So that gives us a bit more control there to work with. Did I hear? Yeah. Assessment. So under assessment and authorization, age, no refusals, mental capacity, mental disorders, eligibility, best interests, mostly generated for each other under successive authorizations. Under the LPS, you're looking at the mental capacity, mental disorders. These elements include DoLS assessments, but completed DoLS, it's fair enough to be valid existing assessment. So if you've already done the DoLS assessment, it's valid. You don't have to redo it. Necessary and proportionate conditions. Under DoLS, you had to have necessary to prevent harm. Under this one, although not new, necessary and proportionate still remains a key priority. Roles removed. So specifically trained mental health assessors must be a doctor-specific person, best interest assessor, social worker, nurse, occupational therapist had to do the DoLS. Under the new one, the assessments are more flexible, with an assessment being prepared by a range of professionals for different reasons. Some of this still can be carried out by experienced members of healthcare professionals, but without formal frameworks being applied to DoLS. So in other words, carers can contribute to the LPS process. And the new role, approved mental capacity professionals, the AMCPs, is a new formal role, especially for trained experienced people, to help ensure that the rights of individuals are being upheld. So what we're looking at here is a bit of an overview, but making it much more flexible and a bit more less red tape and a bit quicker. Extended the scheme to domestic settings. So liberty protection safeguards will apply to individuals residing in domestic settings. So if you do community care, this is really important. It means now in people's own homes and families, shared living, supported living, we can now put LPSs, which is a massive, massive change. Review the criteria for assessments. So here, Responsible bodies can use any staff where necessary, as long as they've got the skills and knowledge, e.g. the care manager. So a lot of this is going to fall on the home managers to do, unfortunately. However, assessment of mental capacity and mental disorders must be completed by professionals. In other words, mental disorders no longer require specialists, e.g. it could just be a doctor. Pre-authorization reviews, so this is about getting your paperwork through. It's still done by the responsible bodies assigned to somebody, not involved in the day-to-day care of the person, so it's an independent person. Read and complete the assessment, do not meet the person. They review the information and determine whether or not it's reasonable, so what the assessment is it fair and reasonable, and they're an approved mental capacity professional and must be appointed with them. Authorization now, the responsible body, so this is no longer legal, it's not going through, it's still legal, so it's not going through the courts, it's done via local authority and the NHS. And anyone considered to be an appropriate body does not have to be a professional. So in other words, if it's going through the local authorities, it can just be an independent review to make sure it's fair. So to apply an LPS to somebody, the person must be 16 years and over. They must be a person that lacks capacity to agree to the arrangements of the deprivation of liberty. The person must have a mental health disorder. The arrangements of deprivation of liberty meets the acid tests. So that do they understand? Can they retain? Can they repeat and understand the consequences? The arrangements are necessary and proportionate to prevent harm. Requirement to consult the person and others. The person is excluded from the arrangements under the Mental Health Act. So self-harm, refers to self-harm or harm to others, or if the person is objecting. And is there an appropriate person? If not, the independent mental capacity assessment needs to be done. Then outcome 4, understand how the LPS will impact the role in caring and those that lack capacity. So the Mental Capacity Act, which was reviewed in 2019, Section 21A, Section 1(1)A of the Act, does the person lack capacity to consent to the arrangements of deprivation of liberty? Any personal or behalf of the responsible body to complete the assessment. The assessment may have been done from a previous authorization, so that's the DoLS in. Assessment undertaken by professionals, probably a nurse, social worker, or doctor. Care home managers can arrange these assessments. There is talk that the care home manager can do the assessments and will be extracting a code of conduct regarding possible conflicts of interest. So there isn't a code of conduct at the moment, but they are looking at introducing a code of conduct under the Mental Health Act. When conducting the assessment is to confirm that the person has a mental health disorder undertaken by a registered mental health practitioner, plus any pre-existing conditions of the mental health disorder by the medical practitioner and the responsible body. Legal criteria, do arrangements for the magistrate courts on the deprivation of liberty. So as we've already said, previous DoLS or magistrate stuff will naturally roll into the LPSs, so we don't need to worry about that. Your task is, would this assessment be acceptable to a responsible body? Identify the areas that need amending. So what you're going to have to do in your services is get your current DoLS applications, review them and see if they meet the new criteria for the LPSs and just amend them as necessary. We don't need to worry about Margaret there. So when we talk about necessary and proportionate to prevent harm, we need to establish that your reports, so the current DoLS into the LPSs, first of all, are necessary. So does the restriction is based on a good reason? So why are we suggesting this DoLS Act or this LPS needs to take place? Is it proportionate? So is the restriction in which we're saying you must be followed, you're not allowed to go out, we've got a lock on the door, we have to be with you if you go to the toilet, we have to be with you if you're having a bath. Is that restriction the shortest time possible with a minimal intervention? Okay, so whatever it is we're saying needs to be done, is that proportionate? So again, if we think about Mary, who wants to have, who's refusing to have her pad changed, is it necessary? to do this? What is it we're going to do? What's the quickest time frame we can do it? And what is the intervention? Okay, so that clear care plan. And any member of staff completing the assessment will have to provide evidence of the restrictions being necessary and proportionate. So, for example, if we know Margaret has skin breakdown, if we know that she needs to be washed, dressed and changed, if we know that we may need to do an envelope hold to hold her, that's what we're going to write. We've got step 1, we'll do this. Step 2, we're going to do this. Step 3, we're going to do the final hold. So you need to show that positive behaviour support plan as your evidence for holding people. Legal criteria for a person. So obviously a requirement to consult with appropriate people. Responsible body or care homes need to make sure that they've got the individual, those that are named to the individual to consult, anyone engaged with the individual care, their welfare, any deputy or any appropriate person. And those purposes are to identify the person's wishes, feelings in relation to the arrangement. If you do an LPS, we need to make sure that somewhere on the LPS form, we've got wishes and feelings in the arrangement made clear. And again, if you cast your minds back to those positive behaviour support plans, they were all co-produced, weren't they? They were produced with the individual, they're produced with the family, they're produced with social workers. So again, it's a strong piece of evidence. Exclusions for the mental health assessment. So the mental health assessment doesn't differentiate between people who have capacity and those that don't. It doesn't cover decisions about all aspects of one's life. So in other words, it's still one assessment per thing. Mental health assessment only applies to the assessment and treatment for the mental health disorder. So again, thinking about the dementia or the effects of dementia on somebody's well-being. The mental health assessment applies to anyone who may have an impairment or disturbance function of the mind. Mental health assessment applies to any disorder or disability of the mind, the brain. The mental health assessment looks at the best interest decisions, addresses the risks faced by the person who lacks capacity, and the mental health assessment decisions made to address the risk to the person's health and safety. But again, thinking about all of those things around personal care that we were talking about earlier on in the programme. So the LPS legal criteria is the person objecting. So if they are objecting, does the person wish to leave the place that they're being held in? Does the person want to refuse care or treatment? If yes, the responsible body must appoint an approved mental health professional to undertake the pre-authorization review. The mental health assessment must meet the cared for person and take any actions that they consider to be appropriate and practical. So here, that's that 72 hours that we were talking about. So if you've got somebody that you've done an assessment on, you've already said, look, we're a locked house, we need to keep the doors locked, and they go, but I want to go, and you can detain them, you can do the LPS. The LPS will be legal, so you can enforce it from day one. You'll have 72 hours in which to get that LPS reviewed. And as long as that LPS has been reviewed, then the responsible body would obviously review that. And that's only if the person appeals the LPS. So if the person agrees to it all and says, look, this is in my best interest, I understand these decisions being made, and it's lawful. If they appeal the decision, it goes to the responsible body and they would obviously approve it. But in that duration, it's still legal. Okay, so you don't have to wait for that assessment to come back. Obviously, legal criteria, the appropriate person, everyone will get an appropriate person or an independent capacity advocate. So that's down to the responsible authorities to provide. And if the cared for person has a mental capacity, they must consent to being represented by the appropriate person. So again, just making sure that that's done. Now, this is new. So the LPS process means all individuals have new rights. So the first right is all people in care now have the right to appeal to the Court of Protection. They all have the right to an advocate. They all have the right to a review, and they all have the right to an appropriate person. There are 4 new rights that didn't exist beforehand. And again here, information on rights, the duties to inform the person and others, the rights under the Liberty Protection Safeguards ensures that the copy of the authorization is given to the person and the appropriate person, advocates falls on the responsible bodies. So it's not down to care homes to chase all of this up. Once you've done your LPS, once you've said, look, we need to hold this person in this way, we need to detain them for whatever reason. Once your report's gone in, that's legal and proportionate. It's only once it's reviewed and it's down to the responsible body to give them this information. It's not down to you. A new section power's coming in. So this is called a section power 4B. The section power 4B looks at depriving people of their liberty whilst a decision is respect relevant to the sorts from the courts. So the first condition for this is whether the authorization and deprivation of the liberty is under section 4A. The second condition is that the deprivation of liberty is wholly or partly the purpose of giving life-preserving or sustaining treatment. So at the moment, you can walk out of a hospital and not be detained, because you can make an unwise choice. What section 4B is, if you've gone to a hospital and you've been detained, sorry, if you've gone to a hospital, let's say you've gone in, you're hyperglycemic, you're having, I don't know, a diabetic emergency, you can walk out and refuse care and treatment. Okay, you're allowed to make an unwise decision. What section 4B is that you can now be detained for life-preserving treatment. So if the hospital now feels that the decision you are making is unwise and detrimental to your health, you can be detained under a 4B. And that's different to the nurse's power of hold, which is a section 5, and that's where we can detain you under the Mental Health Act of a disturbance of the mind. So this isn't necessarily to do with a disturbance of the mind. This is to do with the consideration of life-saving treatment and giving the doctors the power to detain you for life-saving treatment. So we're not going to do that quiz. Hopefully now you've seen a quick overview of the new arrangements of the Mental Capacity Act 25 to 2019. We've looked at the key differences between DoLS and LPS. We've looked at the criteria to assess somebody for the LPS, and we've looked at how LPS will impact on the role of caring for somebody who lacks capacity. Do I have any questions from you? And I appreciate that was very quick. Or is that as clear as mud? So basically, for you guys, what would be really useful just for you, your takeaway from this, you know, it's a lot of jargon. I appreciate that. There are some videos on here for you to have a look at. But the one thing that's really useful for you to know is these slides here. So if you look at the key differences, you just need to know the LPS part. You don't really need to know the DoLS part. So if somebody starts talking to you about liberty protection, you now know it's for 16 years and above. You know that it can be applied in the community as well as homes and hospitals. You know that anyone can do it, that's authorized to do it. You know that it's a year into 3 years. So that's your key takeaway bits, okay? You do need to know about the Mental Capacity Act 2019, and I'm sure all of your services will do additional training. I think you do DoLS training anyway, don't you, as part of your mandatory training? So I'm sure you'll do the LPS. Obviously, if you want to show this to your managers, feel free, because I'm sure they haven't seen this yet. This is going to be new to a lot of people, because again, it's been snuck in under the radar. I think it was postponed to go into full operation. It was due to come in April this year. I think it got postponed because of COVID. It'll only be by a couple of months, so it's going to come in. And ultimately, like any new change, you're going to have to train the staff, review your current DoLS applications, look at who your responsible authority is for making any applications. What we know now is if we need to provide care and treatment for somebody, we need to justify what we're doing. And that's what those positive behaviour support plans do under that restraint reduction network training that you've already done. And again, that's all online, so you've just got a lot of reading to be doing. Are there any questions? I've blown your minds, haven't I? You're like, Stephen, you've done it. You've sent our minds into meltdown.
I just want to ask, for how long we'll have all these learnings on the system?
So you'll have it for 18 months. You've got access for 18 months. So the way that your apprenticeship works is we've done the upfront learning, so you've got the year to put it into practice. So all of these videos, all of the PowerPoints, access to everything is there for the year, because obviously throughout the year, we want you to keep practicing and embed what you're learning, because a lot of this is about repetition, repetition, repetition. And ultimately, now you've finished the CHAPS program, as you go through the rest of the modules in your own time, I mean, there are monthly targets. So as you go through, it says month 4, month 5, month 6. You need to try and complete that block of learning in those months. Ultimately, you've got access to everything. And it's there because when we do the professional discussion, this is the theory, this is what we're going to talk about. It's not going to be massive details, it's going to be overviews of stuff. So you've got it to refer back to and look at. And obviously, you're going to have 2 or 3 observations from me. The first observation is over this CHAPS program. It's over these 8 weeks. It's those clinical skills that I covered this morning. That's the first observation. The second observation, which will happen in about 6 months' time, that'll be your second observation. And what I would want to see is that you're using some of this stuff that you've learned. You've become a bit more confident with it. So the idea of the first observation is I can see where you're at, I can see your clinical skills, I can see what you're doing. And then when we do your second observation, what I want to see is some kind of improvement, some journey in which you've traveled. Okay, that makes sense. And what that means is when you do your endpoint exam in probably about 12 months' time now, what we'll see is quite a confident person who could do an assessment and just talk a bit of theory. Yeah. So it's all going to be there for you. And again, like I've said, over the next week or so, I'll be reaching out to you all to book in those one-to-one observations. And then I'll come out and see you. We'll do it. You know, we've got a day together where I need you to be off the floor. So you're going to have to talk to your managers about that, or alternatively, it'll just need to be on maybe your day off or something. You'll need to get consent and let your manager know that I'll be coming in. And that's because I need to show you everything, and then I need you to practice, and I can't be doing that if you're going to be dragged off the floor all the time. But the second observation is practice. Yeah, so the second observation will be live stuff. It'll be, you know, let me come out and see you do an assessment. Let me come out and watch you do something. Because the second observation will be like your end exam. So I know that you're exam ready. All right.
Yeah.
So that's the end of that session. So we'll end that there.